We're going to talk to you this morning about the Supreme Court Litigation Clinic that we have here. Just to introduce myself, I'm from Boulder, Colorado, and I came here to UVA from Georgetown undergrad. I'm a 3L student, and next year I'm going to be clerking for Judge Garland on the DC Circuit.
And I'm also a 3L. I grew up in Goochland, Virginia. I went to Patrick Henry College undergrad, which you've probably never heard of, and I'll be clerking for Chief Judge Batchelder on the 6th Circuit next year.
So just to give you guys a bit of background, the Supreme Court Litigation Clinic is composed of 14 third-year students who are all working on petitions for certiorari and merits briefs at the Supreme Court level, which is pretty fantastic. So Levi is going to talk to you guys first a little bit about the nuts and bolts of what we do, and then I'm going to talk a little bit about the selection process and some of the benefits of doing it, and then we'll open the floor to questions from you guys.
So we do a variety of different things on the clinic, and probably the least sexy thing that we do is we look for potential cases that the Supreme Court might grant review on. So there's 14 of us in the clinic, and we divide up all the circuit courts, we divide up the state Supreme Courts, all 50 of them, and someone will read every case that's been published by any of those circuits every single day, because we have to find these potential cases in order to have cases to work on and maybe be able to get a merits brief, get to go see our case argued at the Supreme Court, which is really exciting. And the case, the Supreme Court does not take very many cases. You've probably read about how they take 80, maybe 75 cases now in a year. They used to take closer to 120, and there's maybe 7,000 to 8,000 cert petitions written every year. So it's about 1%, and thankfully our clinic does a lot better job than 1%. We usually get, I think, a merits case once a year, maybe even more than once a year. So we do a great job identifying cases. The type of cases that we look for are generally where there's a circuit split on an issue. When the Second Circuit and the 7th Circuit say one thing about a particular legal issue, and the 9th Circuit and the 3rd Circuit say another, or where state Supreme Courts have divided. So that's what we're looking for when we're looking for cases. We have to do it generally quickly and do this all the time because there are other Supreme Court clinics out there. There aren't very many. I think there might be 7 or 8 clinics out there, but they also have students looking for cases. So it's kind of a race to see, who can identify these cases. Then it's up to the lawyers who we work with, the professors, contacting the client, discussing it with the client, and seeing if the client really wants us to represent them. And there's probably, in a case, General Motors versus Exxon, they're probably not going to look to the Virginia Supreme Court Litigation Clinic to represent them. We do a great job, I'm sure, but a lot of our cases, we're representing criminal defendants, we're representing people who might not have the resources or even the knowledge to know that their case, actually, the Supreme Court may want to review their case. So it's great, even though we don't interface one-on-one with the clients, that's for the practitioners we work with, that's for the professors. It is great to know that we're actually helping people who want our representation and who might not otherwise be aware that their case could go before the Supreme Court. So once we identify a case, once the client wants the clinic to represent them, then we start work on the cert petition. Generally, there's 14 of us in the clinic, like Galen said. It becomes a little cumbersome if all 14 of us are working on one case at the same time. So we try to have, I think, 2 to 3 cases in the pipeline that we're working on at maybe different stages at one time. So there might be 7 of us who work on a particular cert petition. We get in a room with the practitioners. Some of them are in DC or New York, and they're either here in person or they're available via phone conferencing. And we start talking about the case, and the professors say, "What do you think? What are our strongest merits, positions? What are the arguments that we have to rebut? Is there actually a circuit split here, or is there not a circuit split? Do the cases that these circuits are dealing with vary based, mostly on the facts, not on the legal question involved. So there's a lot of kind of, introductory high-level analysis that's pretty exciting, and I don't think that you might get to do elsewhere, just sitting in a law school class. So we talk about the case. There's generally 4 parts to a cert petition. This might be getting a little bit in the weeds, but one person might be tasked with drafting for the next week the statement of the case, the facts, the procedural history. That's usually not too difficult, but it's actually much harder than you would think it is, trying to condense it, figure out what facts are the relevant facts for this issue, what facts make the Supreme Court more willing to take it. Then we'll have maybe 2 people work on drafting the discussion of the circuit split and 2 people working on the merits. And that's just a great opportunity, as Galen will talk about in a little bit, to be able to work with a colleague who's incredibly brilliant, that you're going to learn a lot from, and that person is critiquing your writing, you're critiquing their writing, you're throwing around different ideas. I think for me, that's been the most rewarding part of the clinic. Then the last part of the cert petition is a statement of the importance. Why should the Supreme Court take this case instead of the 7,499 other cert petitions that they get in a year? So after that's all done, hopefully the Supreme Court is, and the court or the clerks read the briefs for the other side. Hopefully the court takes our case, and then we get to work on the really exciting stuff, which is the merits brief and the reply brief, and prepping our professors for oral arguments, which is really fun. I got to do that in a case that we had argued in the fall, and it's a little bit like payback time for the professors who always cold call us, and it's our turn to cold call the professors, so that's a lot of fun.
Yeah, so as you might imagine, because the work is so interesting, there are a lot of students who are interested in doing it, so the selection process is pretty competitive. We're not sure exactly how many students apply, but we assume it's many, and all of our colleagues are obviously top-notch. So what we do in order to get on is we fill out a little form stating our interest, and we submit a resume and a transcript and a writing sample. And then what the professors are looking for are strong writers who are going to be a good addition to this kind of team that's working on all of these cases that are actually going to reach the Supreme Court, at least the Supreme Court clerks at the cert stage. And also, actually building a little bit on what Levi said, we do a few other things. We also, this semester, worked on an amicus brief at the cert stage with a professor here, which I think is a little unusual, but was on a really interesting constitutional issue. And then we also do production work. So after we've written one of these cert petitions, or a merits brief or anything of that kind, we do rounds of editing as well, because of course everything that we're sending up has to be perfect, and the professors are doing this work right along with us, so everybody's pulling together at that point.
And the Supreme Court has its own style manual. Who knew? In addition to the Blue Book, there's a Supreme Court style manual, Solicitor General style manual.
So that's actually one of the great things about the clinic, is you get a lot of inside information just about the Supreme Court bar, and just a kind of an inside look, because all of our professors, we have one who is a full-time professor and 3 who are also practitioners, and I think they all clerked for the Supreme Court. Mm-hmm. And they all have been doing this work for a really long time, so they have a lot of insight on how the process works. And so for a lot of us who want to do at least appellate litigation and possibly even become part of the Supreme Court bar if possible, it can be really valuable to get some of this inside information right away. The second thing is that the issues that we're working on are just fascinating, because by the time something reaches this stage, and especially for the cases that we're looking for, the issues have been really boiled down and condensed. So we're just dealing with these narrow legal questions. We have to really dig into them and analyze them, write about them. And in terms of the writing process, one of the best things about the clinic is it really just makes you so much stronger as a writer, because even though the professors are looking for strong writers to begin with, what we're doing throughout the whole year is working in these small groups with other students on our writing. So we learn from each other, like Levi was saying. That's a fantastic experience. And we also learn from the professors who sometimes go through our writing very specifically and critique it. Sometimes they give us more general comments, but in all cases, it's really close work on writing with professors, which is kind of a rare experience in the classroom after the legal research and writing that we take the first year. So that's fantastic. And then it also is a great thing to talk about in interviews for other jobs and clerkships that will come afterwards. So many upsides. In terms of downsides, it is a significant amount of work, but I would say it's not so much more than the classes that it replaces, because you get 4 credits in the fall and 4 credits in the spring. So it basically makes it so you don't have to take an additional class in the fall and the spring. So while there is a significant time commitment, it's not so much more than just taking the class would be, and you're still able to balance it with all of the rest of your activities.